development and management of Plot 4, Cadastral Zone E30, Lube West, Abuja, popularly known as River Park Estate, with a view to resolving the lingering crisis affecting the estate and making appropriate recommendations to the administration. Honorable Minister, sir, the committee sat, deliberated, evaluated evidence that were presented, and even we wrote letters to the various parties who submitted memorandum, and we reviewed everything. At the end of the day, we made our findings and we also made recommendations. Honorable Minister, with the clear permission of the Honorable Minister, if I may read the findings out. The parties to the Development Lease Agreement, DLA, and the Federal Capital Development Authority, FCDA, as Lease, and Jonah Capital Nigeria Limited, with RC number 669754 as Lease. From the totality of submissions reviewed, the Lease, Jonah Capital Nigeria Limited, was incorporated in 2006 with a shareholding structure of 40% held by Samuel Eson Jonah, 30% by Adeniran Olatokunbo Ogunmuyiwa, and 30% by Olakita Ogunmuyiwa. 2. The FCT administration granted only a leasehold interest to Jonah Capital Nigeria Limited for the purpose of developing a mass housing project with a tenure of 7 years, which was expected to commence from the date of the last approval. 3. Clause 15.2.2 of the DLA provide that the agreement may be terminated by written notice to the leasee in the event of a breach, including any assignment of rights without prior consent of the FCDA. 4. The committee observed from the record at least 3 separate instances of alienation or assignment of rights and responsibilities by the leasee to third parties without the requisite consent of the lessor. These include irrevocable power of attorney dated 28 May 2015, heads of agreement dated 1st June 2012, and power of attorney dated 22nd August 2013. All these they are annexed to the document to be submitting. The alienation of rights and responsibilities reserved to the leasee under the DLA gave rise to multiple developers asserting conflicting claims on the plot. Most of the development approvals were applied for and conveyed in the name of Houses for Africa Nigeria Limited and Paulo Homes Limited, both of whom are strangers to the DLA, as there is no record of their nomination as representatives of the leasee, nor any evidence of requisite recognition or authorization by the lessor. Your Excellency, we came to this conclusion basically for the fact that for every title, for every registered title, before a stranger or a third party could deal with any title, there must be a connection, usually by virtue of a power of attorney duly donated that yes, I have appointed this person to transact on my behalf. But with respect to Plot 4, the parties to that agreement, the leasing in that agreement is Jonah Capital, and there is no power of attorney registered up to date, donating power to either Houses for Africa Nigeria Limited or Paulo Homes. So anybody who have transacted on that land outside Jonah Capital is actually a stranger to the development lease agreement. I try as much as possible to not to call them interlopers. The failure to circulate, monitor, and ensure proper interpretation and enforcement of the DLA across all relevant departments contributed directly to the administrative dealings with entities not recognized under the agreement. Houses for Africa Nigeria Limited and Paulo Homes Limited usurped the privileges of the leasee by submitting names of subscribers, off-takers for issuance of rights of occupancy, RFO. The expiration and or termination of the DLA does not extinguish the accrued rights of legitimate subscribers who purchase units in good faith Such interests remain preserved under the law, subject to proper verification and administrative regularization. The ownership of Houses for Africa Nigeria Limited, the supposed special purpose vehicle for the project, does not translate into ownership of the plot. Without a valid transfer of rights from the leasee with the consent of the lessor, the SPV cannot assert proprietary rights over the land. Your Excellency, this point is very important because the main contention between the parties is who owns Jonah Capital Nigeria Limited. And because of that, we have entities that deal on the land, they deal on the land on the claim that they have shares or they have acquired shares. Our conclusion or our findings is to the fact that share certificate does not amount to title in land. It is quite different. You may own shares in the company, but that does not give you title to that land. The land still belongs to the company. And as such, you cannot come in your own name or in the name of any other entity to transact on that land. It must be that company that the land was given to. The dual existence of Jonah Capital Nigeria Limited. Here, Jonah Capital, one word. Jonah Capital Nigeria Limited with RC number 669754, incorporated in 2006, and Jonah Capital Nigeria Limited. Jonah Capital, two different words, with RC number 1391654, incorporated in 2017, present risk of corporate identity manipulation. The copies of conveyed building plan approval reveal inconsistency in the number of approved structures in the estate. While the record indicates approval for 7,985 families, deliberations, the committee cited approval for 10,794 families, creating the likelihood that about 2,769 families are occupying units without valid approvals. Considering the number of units approved under various building plan approvals, vis-a-vis the comparatively few rights of occupancy processed, 2,306, there remained a substantial pool of unprocessed title documents for legitimate subscribers. The failure to circulate, monitor, and properly interpret and enforce the provision of the DLA to all relevant departments for information and enforcement contributed to administrative dealings with entities not recognized under the agreement. Your Excellency, we will note that...
No, go ahead, just go ahead. So I can read the recommendation.
Okay, let me go to the recommendation. Okay, so the last will be the second one. Several subsisting court judgments remain unexecuted and unenforced, resulting in a breakdown of law and order, protracted dispute, and heightened security threats within the estate. The committee resolved to discountenance the police report of 7th August 2025 addressed to the Director of Land Administration on the following grounds. 1. The police may validly make findings of fact supported by evidence, but it is not within their province to make pronouncement of law concerning the DLA or matters under the statutory authority of the Corporate Affairs Commission. 2. Paragraph 1 of the report contains material omissions and suppressed facts, while the conclusion in paragraph 5 was drawn from a fundamentally false premise. For this reason, the committee jettisoned the report of the police. Now, going to recommendations. It is the committee's view that the pattern of conduct as identified while reviewing this matter risks institutionalizing systemic abuse, eroding investors' confidence, and gravely undermining the integrity of land administration in the FCT. It is therefore imperative that immediate corrective measures be undertaken. Mere removal of the disputing parties from River Park Estates may not be sufficient. The administration must take decisive steps to rectify these irregularities, ensure accountability, and implement safeguards to prevent future reoccurrence. Accordingly, the following recommendations are submitted for the Honorable Minister's consideration. Remedial directives. 1. Direct that all undeveloped portions of land within the boundaries of River Park Estates be withdrawn and reverted to the FCT administration. This measure is necessitated by the expiration and breach of the DLA and the need to reassert administrative control over the affected plot in line with clause 9.2 of the DLA. 2. Direct that holders of previous customary titles whose plots fall within the River Park estate boundaries and who have developed in accordance with applicable planning and development control regulations be permitted to retain their titles. This recommendation aligns with the subsisting court judgment referenced in paragraph 16.3. 3. Approve the relocation of other affected holders of valid but undeveloped titles to the designated site at Otu District and constitute a special committee to oversee the relocation process. 4. Direct the establishment of a transitional special management committee comprising representatives of the FCT administration, River Park Estate Residents Association, and key security agencies. The committee shall be responsible for harmonizing the list of legitimate subscribers, coordinating estate security, facilitating title regularization and issuance, and resolving outstanding grievances of residents. 5. Direct the leasee to submit all executed power of attorney and other instruments of transfer granted to other developers and subscribers to the Transitional Special Management Committee for review and consideration for possible ratification. Direct that in line with clause 2.4 of the DLA and paragraph 16 of the letter of intent, the names of subscribers beneficiary be forwarded to the committee for vetting and consideration for issuance of rights of occupancy. Direct that all stakeholder departments of the FCT administration are prohibited from engaging in any form of transaction, correspondence, or application with Jonah Capital Nigeria Limited, Houses for Africa Nigeria Limited, Polo Homes Limited, Common Consultant Limited, or any entity or individual claiming or acting on their behalf in respect of River Park Estate, Plot 4 within cadastral zones E25 and E30, Abuja, except under the express ministerial mandate as stipulated in paragraph 32.2 B12. Sir, we also offer corrective measures. Formally declare that the DLA has elapsed and stand void by reason of fundamental breach of its terms and conditions, as well as expiration by friction of time. Immediate and effective suspension of all ongoing approvals, title processing, and construction activities within River Park Estate pending the outcome of a comprehensive audit. Undertake a full-scale physical audit of existing developments and approval across the estate to identify all unauthorized developments, invalidate or void all rights of occupancy and certificate of occupancy procured by parties other than the leasee, other than Jonah Capital Nigeria Limited, because that is the only party known to the DLA, and instead process fresh rights of occupancy and certificates of occupancy in the names of verified subscribers, given that the list of beneficiaries were not forwarded by the party designated under the DLA. Preventive measures. Institute a mandatory interdepartmental review mechanism for all PPP-based mass housing schemes. Deploy automated alerts within the land administration system to flag lease expiration, alienation attempts, and unauthorized applications. Prohibit issuance of approval over plots governed by letter of intent or DLAs without review and clearance by the Legal Service Secretariat. Strategic policy reform. Review and reverse mass housing guidelines to expressly prohibit alienation of plots vis-à-vis shares for land arrangement or any other form of undue alienation. Establish a statutory framework for the verification of beneficiaries and direct issuance of title to subscribers. Amend the standard DLA template to include enforceable performance milestones, defined sanctions, and compliance benchmark. Conclusion. Assuming without considering that all the shares of the SPV, Houses for Africa Nigeria Limited, were purportedly sold to Polo Homes Limited or Polo DD, such transaction would not involve confer ownership of the plot, since ownership would only rest upon due conveyance and lawful alienation of title in accordance with the provision of the DLA and the extant land administration framework of the FCT. The development lease agreement DLA has been flagrantly breached. It has elapsed by a friction of time. It has been declared void by subsisting judgment of the competent court. With the exception of innocent purchasers for value without notice, specifically verifiable subscribers, the continued presence of numerous unknown entities acting with or without the authority of the leasee and without formal recognition by the FCT administration, alongside persistent security breaches within the estate, including threat to life allegedly instigated by interlopers on the plot, strongly indicate that all parties currently laying claim to the ownership, development, or management of River Park estates are in effect trespassers. So this report was attested to and signed by all members, including those who were for it. Thank you.
This will be implemented immediately. Immediately, I will not waste time for this. And I will direct the director of the land to forward to you within the 48 hours. Also, your folks are signed under what do you call it?
Polo homes.
Polo homes. All. Because from what you said there's no authority. It's not even the sea. There's no power of attorney agreement signed between Jonah and Polo homes, or what do you call it, Africa. For Africa. So that all lands you have to give all copies. I don't want to hear a story that today was Tuesday. Today is Tuesday. By Thursday you have forwarded everything, and then you make me a memo where I will now validate all. Then find the subscribers so that they can apply. Let it not be that we're trying to, it will be very frustrating. Sometimes some of them will buy or pay the tax knowing that's the problem that's going on. Every time all these so-called housing developers have problem there. And luckily you say that the lease has expired by exception of time. And there are a lot of breaches. So that is enough to withdraw from it. So I think you also have to, after you leave the press full details, I approve every recommendation made by the committee.